Hello and welcome. I'm Eileen Lannon-Olford, CEO of Business Cape Breton. Thank you for viewing our video business series covering the topics marketing, legal issues in business, human resources, business growth, and business in the community. Cape Breton business people and professionals are featured in these videos, and they wish to share their experience and knowledge to help you start your business and grow your business in our region. We hope that you will find this business series helpful. And at Business Cape Breton, we'd be pleased to assist you in your business plan preparation, marketing plans, and training. Thank you for your time and interest in Business Basics, brought to you by Business Cape Breton.
Thank you for joining us today. My name is Greg Rushton. I'm a corporate commercial lawyer with the Breton Law Group here in Sydney. We're going to speak today about legal considerations that may impact your small business. An important determination in starting a new business is what type of structure you'll carry on business under. There are three main types of business structures. The sole proprietorship. The sole proprietorship is the simplest of the three. The advantages of a sole proprietorship are that it is indeed simple, and you need only register the business name and go. Another advantage of the sole proprietorship is that if you have any losses as a startup, which isn't uncommon, they can be offset against your personal income at tax time for some tax relief. The drawbacks to this sole proprietorship model are that the liability is unlimited. In other words, the business structure and you are one and the same. There's no distinguishing the two. Your personal assets are at risk of creditors if you were to default on any loans of the business. The second type of business structure is the corporation. This is the most common business structure that I see in my practice. The business owner is the shareholder. They are separate legal entities. So the business owner is here, the corporation is here. The corporation has all the powers of a human. It can borrow, it can enter into contracts, etc. If the company were to default on a loan, the creditor, the bank or whoever, wouldn't be able to attack the business owner or the shareholder. There is what we call the corporate veil. Aside from the advantage of the corporate veil, there are tax planning advantages to having a corporation, income splitting when your company begins to make more money. The main disadvantage with a corporation is that it's administratively burdensome, it's more expensive, and it requires attention as you go forward. There are annual renewal fees, and you'll likely need to consult with a lawyer and an accountant. The third and final business structure I'll discuss is the partnership. The partnership is a combination of two or more entities, whether they are sole proprietors or corporations or a combination of both. They are regulated by agreement and the Partnership Act in Nova Scotia. By law, single partners, are liable for the debts of the whole partnership. Partnerships can be particularly complex, and great trust is required between each partner. An important point, whether you're carrying on business as a corporation or as a sole proprietor, you must register your business name with the Nova Scotia Registry of Joint Stock Companies. In summary, the vehicle that you choose to operate your business is very important. I would strongly advise consulting experts prior to choosing your particular business structure. Another important part of establishing your business is understanding your relationship with your employees. A hot button issue these days is the actual classification of an employee. Legally, an employee it's a master-servant relationship. Often companies will contract out to consultants to do their work, and there's significant differences for tax reasons. CRA has a great interest in employers and employees because if you are a legal employee, then your employer is obligated to submit CPP and EI remittance to CRA. And if not, if they're actually a consultant, then that consultant is responsible for remitting on their own, and the employer has no obligations to them. Obviously, the consequences of deeming an employee incorrectly an independent contractor can be bad for the employer because then they will be reassessed by CRA and you will have to submit your EI and CPP from all of those past periods. Basically, without going into much detail, it's a control test that CRA will objectively apply to the facts to determine whether you're actually an employee or an independent contractor. If the employer basically has control of that person, and that's the only person, and that employee is only working for that employer, then you're likely an employee. If you're using that employer's tools, for instance, their space, you're on their time frame, etc. Obviously, when you are bringing on a new employee, you want to set the stage from the start. You want to manage the expectations of that employee, and there's no better way to do that than a good employment contract. There's certain things that you're going to want to look for in an employment contract. You're going to look for the term. So how long are they going to work for you? How much are you going to pay them? And then how are you going to pay them? So for instance, is it a salary? Is it a commission? Are there bonuses? Are you going to be reimbursing them for expenses for certain things? You're going to want to ensure that this employee can carry on the duties that you are setting forth for them. Those duties should be clearly defined so that there's, no vagueness between the employer and the employee. Also, if there's any procedures or internal policies that the employer has, they should be acknowledged in the agreement so that the employee has knowledge of these and understands that they may change from time to time, but they have to be abided by. An important element of the employer-employee relationship, of course, is confidentiality. So you're going to want to have some confidentiality terms in that agreement. The company has, trade secrets, their financial information, their marketing strategies, these types of things you don't want your employees conversing with other potential competitors. Now, of course, we never want to think about what happens in the end, but more often than not, employees will move on to other opportunities. So you want to have stipulations in the contract as to what will happen on termination. Oftentimes, if it's a particular niche industry, you're going to want to have some sort of restrictive covenant. So a non-solicitation or a non-competition covenant in that agreement. Courts are weary to enforce non-competition agreements in small markets because the courts don't want to restrict people from working. However, they are very apt to enforce the non-solicitation agreements, which means, hey, you can't go back, employee, and solicit from my suppliers or anyone else that works for me to get a competitive edge. With respect to termination generally, let's say that the employee is not living up to their duties and responsibilities, and you've tried progressive discipline. So in other words, you've gone to them and said, hey, I think you can do better at this, and this, and I'm going to be following up with you. And finally, you have to make the decision to terminate. You can terminate an employee at any time for cause. And that employee, if they are terminated with cause, would have little recourse against an employer. Also, you can terminate an employee for any reason whatsoever with appropriate notice. The Nova Scotia Labour Standards Code enumerates what those appropriate notice terms are, and they're in Section 72 of that Act. Importantly, if an employee is signing an employment contract, you should recommend that they have independent legal advice so that they understand what they're signing, and it would be more enforceable in a court of law. It's important to note that the statutory minimums in the Labour Standards Code are not the be-all, end-all. Outside of this statutory law, at common law, this employee, even though you've given them the statutory minimum, 2 weeks notice, for instance, or pay in lieu of, they could still take action against you if they have suffered a loss because of your termination. So, for instance, if they aren't able to find another job, or it is a particular niche industry and they can't find a similar job without incurring costs to go elsewhere or something of the like. This is not completely uncommon, but can certainly be mitigated by a more generous severance than the Labour Standards Code would have enumerated. Legal issues aside, practically, the employee-employer relationship can be very temperamental. You can't underestimate the value of communication, feedback, and managing the expectations of that employee, because a synergistic workplace is going to be beneficial for both you as an employer and for your employee. So I've mentioned some statute law, which in the case of termination was the Labour Standards Code. I've listed relevant statutes from an employer's standpoint. That includes the Labour Standards Code, which regulates the standards for employment, such as hours and overtime, vacation, leaves, and termination. The Human Rights Act Obviously, employees can't be subjected to discrimination or harassment. Discrimination is essentially treating someone different on the basis of race, gender, sexual orientation, etc. Occupational health and safety is an important aspect of many businesses. And of course, workers' compensation, depending on the industry, you will be regulated by that body as well. So here are your federal statutes. Of particular relevance are those that CRA monitor, such as EI and CPP remittances, your HST remittance, and of course, income tax. Privacy is becoming a hot button issue in modern times due to social networking and the technology available to both employers and employees. Recently, in 2004, there was new federal legislation enacted called the Personal Information Protection and Electronic Documents Act. It's nicknamed PIPEDA. The purpose of PIPEDA is to set out ground rules for how private organizations may use personal information in a commercial way. PIPEDA is governed by the Office of the Privacy Commissioner of Canada. In Nova Scotia, PIPEDA would apply to any federally regulated industry. So those are banks, shipping, maritime type companies, likely not so relevant to the small business owner. However, it does apply to all private sector organizations that are using personal information in a commercial way. Personal information is defined in PIPEDA as information about an identifiable individual, but doesn't include the business address or telephone number of an employee of an organization, which is important, in instances like advertising on your website and so on. I've included the definition of personal information from PIPEDA. Effectively, you can list the names of your employees, their telephone numbers, and the business address on a website, for instance. However, you couldn't use personal information collected by your employees of someone else without their consent. I'll quickly outline the different forms of consent. Obviously, actual consent is the most effective. That's written consent. You may have commonly used the word waiver. You would explain to them what you're doing, what you're using the information for, what you're collecting, and that particular person would sign off and say, yes, you may use it. There's also deemed and implied consent. Deemed consent would be that person reading a policy that stipulates, hey, I'm going to do this sort of thing, and I'm going to collect this sort of information, and if that person doesn't voice any concern with that particular policy, then they would be deemed to have consented to you using that personal information. The final form of consent is implied consent. It is similar to deemed consent in that there's no actual consent given, and it can be assumed by the employer. For instance, if in a job application, you as an employer receive references listed in this application, you are then going to contact the references and receive personal information about that applicant. The applicant would have impliedly given you consent to receive that personal information by giving you the names of those references that were obviously going to give personal information about you. The overarching rule in PIPEDA, whether consent has been given actually or not, is that the collection of the personal information must be reasonable for the purpose. Two practical examples that arise in business would be the issuance of a company phone to an employee. It would be good practice to have the employee sign an acknowledgement that you would be monitoring that device for work that you've done on it and personal endeavors. Another example would be often businesses will issue an email address to an employee. Similarly to the issuance of a company phone, you will want to receive acknowledgement from the employee that they know you are monitoring their emails. In summary, best practice would be to have an effective privacy policy and to educate your employees on the same. This policy will be dynamic in that it changes over time as technology evolves and the law evolves. As an overarching rule, generally, when carrying on business, you're going to want to think any action you make related to privacy, is it an unreasonable breach of someone's privacy? Finally, privacy isn't all about the employee. Your confidential information as a proprietor should be kept private, and this certainly overlaps with confidentiality covenants in an employment agreement. You will want to have a policy in place for safekeeping of corporate documentation, financial statements, marketing strategies, and this is commonly found in minute books for corporations. Sole proprietors and partnerships will have to create their own type of filing system to keep these documents safe. As Cape Bretoners, we tend to be very trusting of others, but remember, your business is your life, and this corporate documentation can make or break you. That's it for today. Thank you for joining me in discussing corporate structures, employment relations, and privacy as it relates to your small business. I hope it's helpful in your progression as an entrepreneur.